So if you read Article 35 of the Slovenian Constitution here, which says the right to privacy cannot be violated and shall be guaranteed, we're pretty clear on where Slovenia stands, but what about the U.S. Constitution? So, do we even have a right to privacy in the United States? Well, the Supreme Court of the United States says yes. They say they got it from the Constitution. How is that? Well, let's take a look at Roe v. Wade. We all know this is the abortion case, but really it is a landmark right to privacy case. Okay, so in a concurring opinion, here's a quote, "Great concepts like liberty were purposefully left to gather meaning from experience, for they relate to the whole domain of social and economic fact, and the statesmen who founded this nation knew too well that only a stagnant society remains unchanged." What I'm hearing is they didn't bother to put in basic rights, and we're just going to figure it out as we go along. What's the problem with this? The problem is that when you don't state what rights people have explicitly, and your backup plan is to have the courts interpret your rights from whatever existing laws they can draw from, then that gives bad people a whole lot of time to do bad stuff. Do you know how easy it is to get a case to the Supreme Court? It's not easy at all. It's very, very difficult. You don't get to just do it. You have to have a right to appeal, and then they have to decide to hear it. And once they hear it, they may not decide it on the issue that needs deciding on. They may decide it on a technicality. There is one famous business case that is quoted all the time in business law, but no law is actually decided in that case because it was a plurality opinion. So just because a case makes it to the Supreme Court doesn't mean we even get any definitive answers. But what we're being told here is we'll figure it out as we go along. That sounds lazy to me, or like an avoidance measure. I'm not sure which. Well, what else do we have in Roe v. Wade to help enlighten us? This is from a dissenting opinion from Rehnquist. "I have difficulty in concluding, as the court does, that the right to privacy is involved in this case." Well, of course you do. We don't have a constitutional right to privacy. No one bothered to put it in there. I don't blame him. I mean, I want a right to privacy, but I understand where he's coming from. Here's some information on how we get this right to privacy. The Constitution nowhere mentions a specific right of personal choice in matters of marriage and family life, but the liberty protected by the Due Process Clause of the 14th Amendment covers more than those freedoms explicitly named in the Bill of Rights. Okay, so we're getting this from the Bill of Rights, but seriously, why can't we just explicitly name the right to privacy? We can still amend the Constitution. It's not illegal, it's not outlawed. We can do it right now. If we put our heads to it, we can amend the Constitution. I know we can do it. Again, in Stewart's concurring opinion, the full scope of liberty guaranteed by the Due Process Clause cannot be found in or limited by the precise terms of the specific guarantees elsewhere provided in the Constitution. Okay, what this is saying, it's trying to say that we're not limiting ourselves by specifically guaranteeing people certain rights. Look, dudes, seriously, the right to privacy, it's not that complicated. Slovenia did it. And as an independent country that's a democratic republic, well, actually it's a socialist country, but they're democratic. They did it. Why can't we do it? We've had more experience than them. Why can we not do it? I don't know. This sounds really fishy to me. In one of the footnotes talking about the Katz case, there is no constitutional right to privacy as such. And again, it references the 14th Amendment and how we draw out that right to privacy. But do you see the problem here? Every time there's a question about the right to privacy, we have to go up to the Supreme Court or have a lower court analyze a previous Supreme Court decision. And they can't really analyze it. They have to go along with what the Supreme Court said. But when I say analyze, they have to apply it to the facts of the current case and the current issues. Why do we need all this leeway? Can't we just say we are guaranteed a right to privacy? Period. That's the question I have for you. Why can't we just say it? Why do we have to go all around and beat around the bush to get to the point? I can't say what was in the framer's mind, but what I can say of politicians today is just what I've already said. It's an easy way to let bad people have lots of time to do bad stuff. When you leave it to the court to interpret and draw out meaning from things that do not explicitly state what rights we have. I hope you've gotten something meaningful out of this, and if you have, please consider subscribing. Until next time, adio.